Recording. All right, y'all. So give me a second to share my screen. Let's make sure it's full view. Okay. Can you all see the screen? I believe you can. Okay, so let's go ahead and jump into this. I can't see your faces right now. Okay, so if you have a question, again, drop it in the chat, email it to us after, or you can even come off mute. And if you raise your hand, actually, I can even actually see that since that works. So there are plenty of ways to get your questions answered tonight. But remember, again, I'm not a landlord attorney, so if I can't answer your question, I will get the answer for you offline. Okay, so I've kind of given you multiple disclaimers, right? With the information that you hear tonight, it's not specific to any one person situation, right? It may be some of the scenarios we discussed, it may pertain to you or it may not, right? So it's just really general, broad stroke of information, right, for you all to take into account, right? So we've already done our overview of Keys Equity Program in Module 1, right? And then the week after that, we covered financing your ADU. Last week, we did Module 3, which was how to work with your general contractor and architect. And today, we're going to be doing Modules 4 and 5 together, becoming a landlord and landlord legalities, right? And the next week's the wrap up, so you'll get an invite to that one. And today's going to be a little longer than the previous two sessions, so we're going to take our time, right? Some heavier information, okay? But some of the items we're going to cover: how do you find a renter? Do you need a rental agreement? What is a good rent collection process or security deposit process? Okay, what should you know about habitability laws? Excuse me, I always have a problem saying that word, so I'm gonna say it slowly. Habitability laws, and this is super important. So in that section, we're gonna take our time. Okay, this is where landlords need to pay the most attention, right? And also, what are tenant protection and eviction laws? Those two bullet points I think are the most heavy. Okay, how you should establish rent settings and increases, right? So the rent price or the rental rate. What happens when the unit becomes vacant, right? What process do you follow? What can you do? What are some of the concerns? What is a just eviction process, right? And timeline, and what is rent control in Oakland? All right. So let's dive into this first part. And I would say this is really broken into two parts. First part which is right now, is covering becoming a landlord, and then we'll get into legalities in the second portion. Okay. So how do you find a renter? Some great places to advertise. Of course, you know about Zillow potentially, right? Online. HotPads is another website you can leverage. Trulia, I've never used it. I've heard of it, but I'm sure all three are very similar. Of course, you can use online ads and newspaper ads like Craigslist, right? Social media outlets for rent signs, word of mouth. But another one that people commonly forget about is hosting an open house. Typically, you'll see this when there's a high demand for a rental unit, right? Maybe your ADU is super nice with amenities. You might want to host an open house, right, to create that demand for the rental unit. Right, so that's another option. Okay, now if you do an open house, you need to specify the times for the open house, right? What times and what days are you going to conduct open houses? You should always be available to show the rental at those times, so make sure you're there or you have someone there who can represent you and the rental correctly. And just be prepared to answer questions that folks come with, of course. Right, and obviously you can't do this if you're just posting it on Zillow. So if you host an open house, you should certainly take a few extra levels of precaution to be prepared. Okay. Tenant screening and selection. Okay, so when you are looking for tenants, when you're vetting them, landlord should ask all prospective tenants to fill out a written rental application, right? And on that written rental application, you should always ask the individuals to include their employment and income information. And you need to get their social security numbers, right? That's how you're going to get their credit history and the credit report, so you can gauge the risk of renting to certain individuals, right? It's not the end to be all, right? I wouldn't say only look at these items, right? Because you should also be looking at some references, right? Maybe their past rental history, okay? But also the history of their employment. So not just where they work now, what their income level is, but their past employment history, maybe for the last 2 years, right? You're allowed to look at all of those different things, but for sure, get their social security for the credit, and also their employment and income information. Okay. All right, so during the tenant screening process, there are a few different laws you need to be aware of, right? One group of laws are fair housing laws, right? Both federal and state. You have your Equal Credit Opportunity Act, and then you have your Fair Chance Ordinance, which is particular to Oakland for you all, right? We're going to talk about each of these more in depth later in the presentation, but just to give you all a brief overview, fair housing laws, they aid the country, but also California in ensuring that folks aren't being discriminated against on the basis of their race, ethnicity, sexual orientation, and a few other feats, right? As it pertains to housing services. So getting a mortgage loan, getting a rental, or buying a house, right? And then you have the Equal Credit Opportunity Act, which is going to ensure that folks of all various backgrounds can get equal access to credit and loans programs, right? At the federal level. And then Fair Chance Ordinance really talks about ensuring that folks aren't being discriminated against based on like previous backgrounds, like a criminal background, right? Or a disability, right? Ensuring that folks have a fair chance at an opportunity, right? And for you all, that might look like renting out your ADU, okay? Okay, so this is something to note. It's new as of COVID-19, right? So as a housing provider, which you all would become if you decide to rent out your ADU, you are not allowed to use COVID-19 rental debt as a basis to not rent to someone. So if you are screening someone's rental history and you see that during COVID-19, they miss rental payments, that can't be a reason for you to kind of dock them or refuse to rent dwelling to them, right? Okay. And also you all, you see a lot of civil section codes, right? We will send a lot of this out to you all in that resource email that you'll get from all the slide decks, okay? Cool. And as always, when you are screening tenants, you can always reach out to us at RNHS and we'll support you in navigating that process, okay, for your ADU. So can you rent to friends and family? Well, of course you can, right? I think many of us, that's the reason we're building an ADU, right? What are some of the pros? And we'll talk about some of the cons in a moment. You only see 3 here listed, but I'm sure there are many, many, many more that we can think of, right? But what are some of the pros? Well, you have a personal knowledge of these individuals, right? You're not afraid to have certain tough conversations maybe with them, or maybe you are, that could be a con, but you have a personal, you know their personal background. You can help them out, right? That's another great reason that you would rent out to friends and family. And they may be less likely to disappear, not always, but I know you wouldn't expect them to run off, right? You wouldn't expect friends and family to do that. Whereas a stranger that you rent to, you may not be surprised if they just one day up and leave and break their rental agreement of some sort, right? What are some of the cons? They may expect special treatment, right? The next one says relaxed environment. That just means maybe they may not be cleaning up as often as they would in another rental unit. They may be making a lot of noise late night, going against your noise ordinance that you should have in your contract that we'll talk about in a moment, right? It's too relaxed of an environment for them. And it may strain your current relationships because of that. So that's another con, right? Okay. So rental agreements, California does not require you use a written rental agreement. That's a funny phrase, a written rental agreement, right? Although us at RNHS, we would highly recommend that you use rental agreements. Do not bring folks, whether it be family, friends, or strangers, into your ADU unit without some sort of rental agreement, right? Now, if you need a suggestion on the type of agreement that you should use, you can use the California Apartment Owners Association website or the Mellow Press Guide, which we'll send out to you all after the call as well. They have examples of these rental agreements, but always consult a landlord attorney to vet your agreement, right? I'm going to keep mentioning that. If you ever have questions, if you need an agreement looked over, a landlord attorney is the person to do that, okay? So now we're going to talk about what all should go inside that written agreement, okay? This is just some of the items. Again, your landlord attorney is going to review your draft to help you come up with this draft, and they'll ensure that you have these items inside of your document, right? You need the names of all the tenants and occupants, okay, inside of the rental agreements. So whether they're a couple that's going to be renting out your ADU, whether they're just random people who are going to both live there, all of the names of all the occupants need to be on that rental agreement. Let's see here. Something else that you should note when you have multiple people entering into a rental agreement with you. Let's say one person moves out. Well, whoever's left in that unit is still responsible for the entire full amount of the rent, right? And that's something that they'll see spelled out to them in the rental agreement. Okay, so you can legally seek out the entire amount of rent from any of the tenants who are on that agreement, even if one violates their lease agreement. Okay, cool. You should also include a description of the rental property, obviously your address, including the building and unit numbers if you have that. And you want to note any specific storage areas or any areas that folks are able to park, or any areas that your tenants are not able to use or leverage or open up or access, right? That should all be spelled out in the rental agreement as well. Okay. The term of tenancy. So how long are they allowed to stay, right? You may see a short-term month-to-month lease, but a lot of times, and most of the time, you'll see a 12-month lease. And I would recommend that you all leverage those, but it just depends. Maybe you want it to be month-to-month, and that's okay. That's common as well. But in general, you'll see a 12-month lease typically. Someone's coming in, right? And for all forms of tenancy, you want to ensure to note the start date of the tenancy, so when they're allowed to move in, and obviously when that tenancy would end, so when it'll expire, when they have to leave. Okay, cool. Security deposits and fees. Okay, so one of the biggest things that comes up between tenants and landlords are disputes around security deposits being kept when tenants try to move out. So to avoid this, you should have clear language in your rental agreements about the dollar amount of security deposit, what's the acceptable use of the deposit, and what are events that will cause you to hold someone's security deposit, right? And we'll talk more about this later in the presentation, but there's something you will do that's called an itemized list, right? In which you'll let a tenant know the items that they have to clean up or correct. Otherwise, you'll have to use their deposit, right? So we'll talk more about that in a moment. Okay. And give me a second. I see a question in the chat. So do I recommend a property manager for Oakland? Absolutely. Well, I'll say this. I personally like property managers. I think if you're someone who doesn't have a lot of time to manage it on your own, then it will be great to leverage a property manager, but there's a cost associated with property management, right? So a lot of times folks will recommend that if you're only renting one unit, then you just focus on it yourself without hiring a property manager. And then once you get to about 3 to 5 units under your belt, then you bring on a property manager to eat up some of that cost. And also because there's more work on your end. So it'll be nice to have a property manager there. So I think it comes down to how much time do you have to manage the unit, right? Because there are certain laws that we want to make sure we're following, and the property managers can ensure that that happens too. So it's not all on you. Cool. So again, your best way to combat this or fight against, that dispute between your tenants and the security depositors, just ensuring that they know exactly what their security deposits will be held for, right? Also, repair and maintenance policies is something that's super important to include in your drafts of your rental agreement, right? The tenant should know what they're expected to maintain daily and weekly, and what you'd maintain as a landlord. And I'll say this about this slide. Typically, you can break these maintenance up into 2 categories, right? You have cosmetic, and then you have structural. The cosmetic stuff like paint, putting up shelves, holes in the wall. The tenants more than likely will take care of those things, or you may have them take care of that. And then you are certainly responsible for the structural maintenance of the building. So like the seismic bracing of the two-story deck, uh, sloping of the floor, roofing, right? Stuff that can become dangerous to your tenants, you'd be responsible for, right? Okay. Oops. Okay. You should also include the instances in which you're allowed to enter the rental property, right? So to avoid tenant claims of illegal entry and violation of privacy rights, your lease or rental agreement should clarify your right to enter the rental, right? Are you allowed to enter it within 24 hours, 24-hour notice? Are you allowed to run right in during an emergency, which you are typically? All of that should be spelled out in the rental agreement, just so there's no disputes about illegal entry. Okay. Uh, Rules, right? If you have clear-cut rules like no smoking, no pets, that should obviously be in your rental agreement as well. So there's no confusion. There's no pets, right? No illegal, like no partying or whatever. You can decide that, but it should be inside your rental agreement in order to enforce it. Okay? And obviously contact information. Tenants need to know who to contact in the case of an emergency, who to contact if they're trying to pay rent and it's the system shuts down or maybe they're going to be late. All of this needs to be inside the rental agreement, right? Who do they contact for what and who do they contact for what and why, right? Who do they contact for repairs, for example? Is it a property manager? Is it you and you contact the property manager? You want to get all of that addressed for them before moving folks in. Okay. Cool. Communicating with your tenant. So when you think about yourselves as a landlord, these are, I would say, well, hallmarks of good, right? In a way, how to be a genuine landlord, a good person, right? But you want to have effective communication. You want to be timely, professional, and fair with all of your tenants, right? Regardless. And if you are this way, if you show hallmarks of good, you're more than likely maintain really good relationships with your tenants, right? So just a reminder to try to be the best person you can be when being a landlord and treat your tenants fair and respond to them in a timely manner. I think you all will be okay. So we started to talk about property management a little bit, right? So what are some pros and cons of hiring a property management company, right? And there are many more pros than what we see here. But they should be well versed in the laws, right? A lot of what we're talking about here, you can hire a property manager and they will ensure that a lot of this stuff is met, right? They should be maintaining good records. Otherwise, what are they there for, right? But you should still maintain your own records, I would say, right? Because you may have to audit your own property management company, right? And ensure that they're following the processes that you know they should be following, okay? And they will save you time if you have a really good one, right? They're not there to complicate your experience. They're there to make your time easier. And what are some cons? They might be expensive for sure, right? I believe the one that I used in the past was they wanted 10% of the rent each month, which I don't think was bad because my family and I, we just weren't able to manage that property at the time, right? But it varies and you can always negotiate rates. So remember that. And staff overturn, right? For example, you don't own a property management company. So let's say you hire one to manage your properties and all of their staff quits, or the folks that were managing your property and built relationships with your tenants are gone. Well, that's a risk you take, right? So something to think about, right? Okay, so what is a good rent collection process? So 2 reminders here, offer multiple payment options. A lot of times we see landlords only offer the ability to send rent in the mail. It's 2023. It helps to have an online automated ability to pay rent now, right? But also keep that cash option as well. And as soon as you get the check, deposit it promptly. Okay. I wouldn't recommend deposit your checks into your personal bank accounts. I would set up an account for the rental property, right? That way you can always track what goes in and what goes out of there more easily. right? So we'll talk more about how to set rent and how high up you're allowed to increase it later in the presentation. But initial rent setting is really determined on the area that your home is located, right? So you'll use a comparable analysis, okay, to do this. So you'll take your property, and I would say use a 5-mile radius. Look for properties that are similar to the look and the size of your property, and see what they charge for rent, right? And take the average of that. That's around what you should rent yours for. Okay, there is another website, I believe it's called Rentometer or Rentometer. It also allows you to get an idea of what rents are going for if you just type in the zip code, and you can do this for any state and city, right? So it's super cool if you want to just play around with that tool. We'll send it out as a resource as well, but you could just do it yourself by looking at the using a 5-mile radius, looking at comparable properties, meaning properties that look the same as yours or similar in size and look, and then see what they're charging for rent, right? So that's the best way to set your rent for your rentals. Okay. Measure EE. Okay, so this is something else that a property manager will help remind you of. They should be well versed around if they're in Oakland, right? But each year, property owners are required to pay a fee for each rental unit that you own. So let's say you own 2 rental, or if your property is covered by the rent adjustment ordinance or the just cause or eviction ordinance, which we have not yet talked about in the presentation, and we will. But if they are covered by either of them, then the fee is $101 per property, right? And if the fee is paid on time, then you can collect half the fee from the tenant's rental unit, right, and rent. So if you have more questions about this, I would definitely consult a landlord attorney in Oakland because they'll know all about this as it pertains to your ability to increase your rent. All right. Cool. Okay. Now, we touched on this early in the presentation, but when a unit is vacant, what needs to happen is the landlord must prepare an itemized statement, right, to send the tenant that's leaving to inform them of repairs that you as a landlord believes they should perform in order to avoid deductions in their security deposit, right? And then after that, after they check off things on that list, you're going to do a final inspection walkthrough with them to ensure that, hey, everything's checked off and you get your security deposit back, right? I've seen landlords skip that and just take folks' security deposit and say, oh, this was broken, this was broken. Well, you didn't tell them that they needed to fix it, and then you just took their security deposit, so now they want to take you to court for that security deposit, all right? Okay. And some other concerns, aside from folks wanting to keep your security deposit, quiet hours may become more important when you have tenants, obviously, right? Especially if you're living there with them, you or your neighbors may need certain time where there's just no noise, right? So don't let lease rules slide. If you have needs, right, for your property, for your neighborhood, make sure you insert those inside your agreements, right? Yeah, so we don't have to say too much about these. There's kind of repeating messages that we've already discussed, right? And we'll talk more about just cause in a moment, right? But evictions are complicated, right? So in general, a rule of thumb, if you are looking to service an eviction, you need to call a rep counselor, okay? We'll talk about what that is in a moment. All right, but I believe RAP, and I think RAP stands for Rental Assistance Program. Yeah, Rental Assistance Program, Housing Council. So yeah, that's who will be able to support you in getting out that eviction notice, right, legally. Okay. So now we're going to dive into the actual legalities of being a landlord. We touched on it towards the end, but now we're going to dive a little more deeply. And like I said, I would reach out to a landlord attorney if you have questions, or someone who works in the rent program for the cities, right? They're really, really good with answering questions for landlords. Cool. So this is part 2. All right. Thank you for staying with me if you're still here. And this is the overview. Okay. So we touched on fair housing laws a little bit already, but we're going to go more in depth. We'll talk more about the California Unruh Acts. We'll talk a little bit more about tenant screening, again, habitability, rent control, and just cause evictions, super important stuff there. Entry rights for you as a landlord into your rental units, and what is reasonable accommodation. Okay. So as a reminder, right, this is super important. Fair housing laws, it's super important not to memorize them, but just to understand like what they are and where to find more information about them, right? But you'll notice there are federal fair housing laws, and there are also fair housing laws for California specifically. There's a tremendous amount of overlap in that law. So typically it's best you can follow either or and be in line usually, right? But what they eliminate is the unlawful discrimination to the provision of housing because of race, religion, color, or sex, right? And that includes pregnancy, childbirth, medical conditions, right? Disability, gender, perception of gender, sexual orientation, marital status, national origin, ancestry, familial status, right? Said disability, source of income, immigration status, and medical condition or age. So it's a whole lot. You're not going to memorize that. You don't need to, right? You should just know how to look it up, or your property manager needs to know that this exists. They will. Okay. So no discriminating, right? And if you feel like you're going to be discriminating, I will consult the landlord attorney, right? And they will let you know, right? I wouldn't do this, so they can consult you around that. Okay. So who has to follow fair housing laws? So yeah, when does the law apply? Anytime you're renting or leasing real estate, selling real estate, you're lending out mortgage products or insurance products, right? Advertising these products, or homeowner association actions, right? So HOA, right? Actions, okay? They're governed as well by fair housing laws, and it's always to protect us. Just want to go to. Okay, so identifying discrimination under both state and federal fair housing laws, you have to make sure that the tenant is advertising as well as the tenant. Well, sorry, make sure that you as a landlord, when you're advertising for tenants or screening for tenants, that you are not discriminatory, right? On the basis of what we just discussed on the previous slides, right? But that also pertains to your property manager. Sometimes if you bring on a property manager, they'll do the vetting of tenants for you. But like I said, they'll be very well versed in the laws. So you'll be okay in that regard. You should be okay, right? Some unlawful discrimination that can include criteria or behavior that appears neutral on its face, but is particularly negative for certain groups of people, right? And that can look so many different types of ways. That's why your rental agreement should be ran through a landlord attorney, because they'll stop you and throw up red flags, right? And that's kind of what the last item is mentioning as well. Okay. Familial status, right? Protections against discrimination under this law. It prohibits the discrimination in housing against families with children under 18, meaning someone like you all renting out your ADUs can say, if you're allowing families to live there, you can't say, I don't want to rent to your family because you have a child under 18, right? Can't do that. You can't refuse to rent to couples because they're unmarried and you want them to be married, or refuse to rent to households with children or kids below any age, right? So items like this is what they mean by familial status. Okay. Now, if you wish to limit the number of people who can stay in your ADU, you can do that, right? But again, your landlord attorney will let you know whether or not you're in line. You're in line with the city's ordinance, right? With how much you can limit that. Okay. And it says here limitations on the number of occupants can arise during tenancy as well as the time of rental. So for example, your tenant may have a baby, right? So you may move two people in there, then they have a baby, right? Now, if you try to evict them, then that can be considered unlawful discrimination. And it actually happened to my family, actually, when they had me. We got evicted when we lived in Richmond. And, you know, at the time, I'm not sure if it was unlawful, but it is unlawful to do something like that, right? Okay. It's also unethical, right, to discriminate based on the source of income, right? So you can't reject tenants because you don't like how they make their money. You know, you work for AC Transit or BART. Well, I don't want to rent to you because I heard BART's going to strike, right? That's not up to you to decide. It's discriminatory. Okay. California's Unruh Act is very similar to the Fair Housing Acts, but it ensures that folks can't discriminate on the basis of race, color, religion, ancestry, right? Disability, national origin, medical condition, sexual orientation. We've heard this once before, right? And this really applies to businesses, right? So banks, restaurants, hotels, housing providers still, right? That's kind of like the fair housing, and then the religious organizations and nonprofits. So all business establishments are covered with this law, not just housing. Okay. Um, Under the Fair Housing Act, you must also show accommodation, right? If there's someone who's disabled. Now you can ask for documentation that proves they need like a service animal, right? And they need that service animal to be with them daily inside the home, right? Obviously. So you can ask that they provide you documentation that shows proof that they need that, but you can ask them on what type of disability they have, right? Just documentation where it says, hey, I'm required to have a service dog, maybe, right? That's fine, but you have to accommodate them reasonably. Okay. And there's a question. That's a great question. Is there a way to make your ADU rentable to 62 and older only, or a senior rental unit? There is, but I'm not sure about the exact process to do that, but there certainly is. I can connect you with a landlord attorney that's who can guide you through that process, what that would look like. But I've seen that before. Yeah. And it might depend on, I mean, obviously definitely depends on your city ordinances. So I don't want to say yes or no just yet. I have seen it, but I would definitely recommend that we consult the landlord attorney to get that confirmation though. A great question. Okay. All right. So just to wrap this slide up again, if someone has a disability and they're going to need a service animal or some other sort of accommodation, you do need to accommodate them. And if you're going to require proof, that's fine, but you can't ask them what type of disability, right? That can almost come off as discriminatory if you start to probe too far into that. Right. So the fair chance ordinance, right? This is again talking about making it unlawful to discriminate against tenants because of their criminal background, right? Now you can have some restrictions, right? Again, you'll need a landlord attorney to let you know, yes or no, I can't, it's okay that I don't accept this tenant because of this background. And they'll let you know. But in general, you can't blanket disqualify someone based on having a criminal record. That's not allowed, right? Cool. Now, habitability laws, super important, right? Habitability, right? It has to deal with how well someone's able to live, right? If a home is inhabitable, that means it's super not safe to live, right? So what makes a home livable or an ADU for you all livable, right? Um, it means the rental meets basic requirements, and that means uh, a roof that's not cracked, sloping, has leaks. You have cold and hot water, right? You have a water heater that works. Flooring is not slanted. You don't have any structural issues with the building, which will put it in danger of falling. There are no dangerous environmental elements, meaning maybe like lead paint, right? You don't have any lead paint. Um, yeah, and there's reasonable protection from the criminal elements as much as can be, right? Like there's locks on the doors, right? Okay. Now, as a landlord, you all are required by the state and by the country, if you have Section 8 tenants, to maintain those standards of health, right? You can't waive, a tenant can't waive their right to these laws, right? I mean, this is their human right to live in a place that's habitable, right? Cool. And you'll see, honestly, a lot of overlap with the local and state law, which makes a lot of sense, right? But under state law, a unit is deemed uninhabitable, meaning it's not safe to be there and you can't really rent it out if it substantially lacks the following: waterproofing and weatherproofing, right? So if it starts to storm, is it all wet inside the AD, right? Is there sufficient installation, right? Is there, are the windows sealed, right? Those types of things are super important, right? Uh, is there running water, right? Does the gas work correctly? Is there hot and cold running water, right? If there's a heater, does it work? If there's an AC, does it work? Okay. Um, is there lighting? If there's lighting in the ceiling, do those lights come on, right? Are the electrical outlets up to date? Are the fuse boxes in the bedrooms outdated, or are they updated to circuit breakers, right? Who knows? So all of those different items are things you need to consider. Okay. Now, what does it look like, again, if your home is uninhabitable? These are some examples, right, of those items on the previous slide. You have trash or garbage in common areas. You have like rats and pests, vermin on the property, and probably because of all that trash, right? Not just inside the unit. Insufficient garbage receptacles. So like have 2 rental units but have 1 trash can. It's not going to work. Dangerous stairways. Maybe you have an entryway deck that's wobbling, not safe. Insufficient lighting. Again, if you have lights in your ceilings, do they all work? Do you have outside lights coming into the homes? Do they all work? If there's lights in the parking structure, do they work? All right. Is there a place to safely get mail delivered, right? Do you have a mailbox? And if you do have a mailbox and you live by multiple people, does that mailbox have like a lock on it, right? Again, do the door locks not work, right? They should work, right? Window locks as well, right? The locks should work. If they don't, then it can be, your home can be deemed uninhabitable, or your ADU, right? And home, they both apply here. Okay. So you cannot retaliate against a tenant if they are seeking out repairs, regardless of whether or not you agree with it, right? You need to go make those repairs, and it should be done by someone who's licensed, right? Even if a tenant skips out on rent, if there's something that needs to be repaired that they're requesting, you do need to still make that repair, right? California is super protective of tenants, as it should be. So that's something to just to keep in mind. So how do we handle those requests when they come in? Take each one seriously. Always have someone licensed, complete the inspection, and have someone licensed make the repairs if needed, right? And document all the steps you took as a landlord, right? Don't skip out on that inspection. If they say something is messed up or needs repairs, always have a licensed professional go conduct the inspection. And don't do it because you think they're trying to pull one over on you. You're following a process that you know you need to follow. That's all, right? And you can even put this process in your rental agreements. That way there's no one's thrown off by it. Okay. So what is the Tenant Protection Act? This is super important, right? But in general, if you look at the green at the bottom right, the Tenant Protection Act covers eligible renters in 2 ways, right? You're protected from unjust evictions, meaning folks can't just kick you out without certain notices, and then unfair rent increases, right? Which we're going to talk about more now. So AB 1482, which is also known as the Tenant Protection Act, it protects it notifies landlords in California that you're only permitted to increase rent 5%, right? Plus 10% of the annual inflation rate, right? And that annual inflation rate is also known as the Consumer Price Index, which you can find online, right? But you can only add 10% of that CPI onto your rent of 5%, right? So 5% plus the 10% of the annual inflation rate. Okay, so keep 5% in your minds. That's typically where the amount that folks do increase rent in Oakland, in California, right? But you can also go a little bit above that and add on 10% of the consumer pricing index. Okay. So you're allowed to increase it, but you're not allowed to just go crazy with it, right? Cool. So the rent adjustment program, right? So that when we talked about those RAP counselors, right, that you should contact for rent increases, right? So or evictions, that they work for the rent adjustment program, right? So if you want to again evict someone or questions about increasing rent, I would definitely follow up with the RAP counselor, right? Because this is what they're experts in. Okay. But that information we just discussed about the 5% and the 10% additional increase from the CPI, that was set. Sorry. No, I don't want to say that. I was going to say it was set in 2020, but that's when it was sent into place. But the rent adjustment program came about in 1980, and they're the folks who worked to get some of those ordinances passed, right? Like the annual rent increase ordinance, right? So there are folks who are advocates for tenants, or that's why we can leverage the rent adjustment program to ask questions that we have as it pertains to rent control. Okay. Cool. So what types of properties are covered by the rent adjustment program, right? And the just cause law. Okay. ADU conversions of an interior of an existing dwelling, right, or conversion of another structure on the property if the existing structure has a certificate of occupancy before 1983. Okay. So if your property, if you got that certificate of occupancy after, right, January 1st, 1983, then it wouldn't be covered by this law in Oakland. And we're going to talk more about what that looks like now. Okay, so what other types of properties that are covered by state rent control, right? An ADU that's brand new, ground up, and was built after 1995, right, or at least 15 years ago. So I will say this is where we start to get into the weeds of these different laws. They have very odd timelines, like 85 to 95, and then sometimes 10 years after that or 10 years before. So I would just highly recommend, instead of trying to memorize this information, right, which I wouldn't even, I mean, you can try to memorize it, right? It's good to know and have it, but you just need to know the contact a land use attorney, right? If you want to know whether or not your specific property is covered, okay, by rent control of the just cause ordinance. All right. So more into the weeds, what are the types of properties that are covered by the just cause law, but not California state rent control? See, so that's kind of confusing, right? It's covered by the just cause law, but not California state rent control. And those are ADUs that are built out of a building that was first built between January 1st, 1983 and 1995, and not owned by a nonprofit or another exempt owner, right? So instead of trying to memorize that, if you have questions about it, I would just reach out to a land use attorney and they'll tell you, right, whether or not it falls in there, or a RAP counselor as well, okay? And they'll be able to tell you whether or not it falls in line with some of these ordinances. Okay. What types of properties are exempt from Oakland and state just cause law? Your principal residence is if a unit is on the same lot where the tenant's unit is located, right? And you share a kitchen or bathroom with the tenant. So it gets really into the weeds there. So I would always recommend consulting with a land use attorney. And the reality of it is most of our units are in Oakland are covered by these ordinances, right? Just not all. So just don't assume. Okay, so this slide sums it up. So when we send this deck out to you, I'd recommend focusing on this slide, right? But just so you know, or remember, Oakland has both rent control and a just cause ordinance, right? These rules don't cover all properties all the time, and I think that's what makes it confusing for us. But in general, in Oakland, if your rental property has a certificate of occupancy issued before January 1st, 1983, and it has 2 or more units, and is nonprofit and exempt or other owner exempt, then it is subject to both local rent control and just cause ordinances. So I think most properties will fall in line with that, right? In Oakland. Okay. Fourth bullet point, in Oakland, if your rental property has a certificate of occupancy issued after 1983, but before December 31st, 1995, right, then it is subject to the just cause eviction law, but not the rent control law. So that's where it kind of gets confusing again, right? But again, I would just recommend working with a land use attorney or a RAP counselor to confirm this information for your individual ADUs, right? And we can connect you to that resource if you have more questions about your specific ADU or property. Right. Cool. So if your unit is covered by the Oakland's rent control law or ordinance, right, you may increase rent once every 12 months. And remember, we have to follow that 5% and plus 10% of the consumer price index rule, right? Now, if you do go up on rent, you need to serve the rent adjustment program, RAP. Remember that acronym, RAP. The rent adjustment program. You need to serve them a notice of when your tenant first moves and with the rent increase notices, right? So any notices you send your tenants about having to temporarily leave their property, having to permanently leave, you need to also file that same notice with the rent program of the city, right? Okay. Serve 30-day notices specifying the reason or basis for an increase. So don't just raise the rent, right? Give a 30-day heads up and a reason for it. Okay. Maybe cost of living has gone up and the dollar amount, right? Maybe you are just doing your annual increase, or maybe you've done some structural repairs and their ability to live in the space is going to increase. Live comfortably is going to go up, right? Maybe that's the case. Oakland publishes the allowable CPI amount annually, right? So again, you can Google this, figure out what the consumer price index amount is. And remember, you can only take 10% of that and add that on to the 5% that you would increase the rent. Okay. And if you miss taking the CPI increases, you may bank or catch them up, right? So you can add these together. And I would consult with again, a land use attorney around how to do that. I couldn't really consult you around that. But they would definitely be someone to speak with if you have questions about how to do that. If you weren't able to take advantage of that 10% added onto your 5. Okay. So there's ways to catch up and get your money. More about when and how you can increase rent, right? If your ADU or your rental unit is covered by the Oakland Rent Control Program, then you can honestly petition, right, for rent to go above the CPI increase of 10%. A lot of times landlords do advocate for that, right? Now, what are some valid reasons to increase rent after petitioning the Oakland Rent Program, Oakland Rent Adjustment Program, right? Increase housing services costs, right? Maybe it costs more to run your housing service providing business, right? Maybe it costs more now to do capital improvements and build your deck or fix the amenities around the units, right? Maybe those costs have gone up, so you have to raise rent. And that's a fair return, right? But in general, remember, there's a 10% cap for whatever combo of valid legal reasons that you come up with, right? That 10%, there's still a limit there. Now, once your tenants leave voluntarily, right, you can set the rent at whatever level you wish, but remember, you should be doing a comparable analysis. So it's not really set the rent to whatever level you wish. If you do that, your property is going to be vacant for a very long time, more than likely, right? You should still use your comparable analysis. Take your property, look at the location, look at a 5-mile radius, take 3 to 5 properties around your home that look similar in size and amenities, and see what they're renting out for. And you would do the same thing for your ADU, right? What do ADUs in the area within the 5-mile radius, what are they renting out for that are similar size and design, right? And sometimes if there's no ADUs nearby to do that comparable analysis, where you might use like a studio that's very similar to your ADU, right? Or a home that's more similar in square footage to your ADU to do that comparable analysis, right? Or you can contact the rent adjustment program and they can tell you they can give you great information about what rent should be for your ADU, right? Okay, and we covered this again. It's kind of just repeating that information. All right, this is important. What if you want to replace a renter in your ADU with a family member? Okay. So if you have an ADU on your property and just one other dwelling, then Oakland will consider you to own a duplex, right? Um, and you would fall under the and you would no longer fall under the just cause ordinance because you live in one of the units and then um, you have someone going to move in the second unit, right? So you wouldn't fall in the just cause ordinance. But you are allowed to replace a renter with a family member if they move out freely, right? You can't kick them out and move in family, right? Because of the just cause eviction law. But once they leave willingly, yes, you can move family in. All right? Cool. So there's no local or state law that really talks about their prohibition, right? Or prohibiting you evicting a tenant to move a friend in. But in general, right, you should follow the just cause eviction ordinance, give folks notices, don't make up reasons to evict folks, right? Um, I mean, you can volunteer if you want to move. This goes for friends and family, right? If you want to move friends and family in, you can negotiate that with the tenant, but they don't have to go. That's just the case, right? Um, Now you can request that they voluntarily move out after their lease is up, but you'd have to negotiate it with them to break it, and it's usually you would, right? But now let's say they do voluntarily move out, well then you have to pay for their relocation, okay? If they do volunteer to do that, pay for the relocation. Okay? Cool. So we're starting to wrap it up. It's nearing the end, so now we're gonna just go through this again and talk more about uh, kind of protecting yourselves, right? And how not to be on the negative end of a potential lawsuit. So back talking about security deposits to wrap it up, right? In general, you must return the security deposit to the tenant with an itemized statement of deductions, right? 21 days after the tenant has returned the keys and left the property, okay? And you also must conduct a pre-move walkthrough inspection. So once they give you the keys and they checked off that itemized list, remember you need to do a walkthrough, close everything out. And you can deduct unpaid rent from a security deposit and the reasonable cost for making repairs to the items in the unit damaged beyond the normal wear and tear, right? But you'll obviously let them know in the rental agreement what those items would be, okay? Because you can get sued for withholding the wrong amount of a security deposit. Okay, so when you have rented out your ADU, and we've already mentioned this, but I'm just going to repeat it here right before we wrap up the presentation because it's super important, right? These are some of the reasons you're able to just go inside of your ADU once it's being rented out. Obviously, in the case of an emergency, to make necessary repairs, right, with a 24-hour notice, or when the tenant is just abandoned the premises, right? But also to draw off a court order if that's the case. Regardless of what the reason is, you need to be giving a 24-hour notice with the details and the purpose about the entry. Okay, is it there an emergency? Are you going to be conducting repairs, dropping off a court or like what a court order? What are you doing, right? And there is the number 5 talks about a law that kind of governs that. Okay, cool. So what I would highly recommend you all do is include, what entry looks like, right, for yourself inside the tenant's unit, inside the rental agreement, what that might look like, what that process might look like, what are some reasons you might need to enter, right? And let them know that you'll always be given a 24-hour notice. And of course, your landlord attorney is going to look over your agreements and ensure that that stuff is there. Okay. And then again, just remember, just a reminder about reasonable accommodation, right? You need to allow, as a housing provider, right, you need to allow folks with disability to make reasonable modifications to the rental unit, okay? And it'll be at their expense, right? So if they need to, I can't think of anything right now, if they need to add different shelving or lower the shelving in the units, right? That's something that they can pay for at their expense. And then usually they'd have to put it back the same when they leave. Question, what are suggestions or thoughts around tenant calling a plumber for stuff up toilets? When should, you make them, when should you pay, when should you make them pay? I can't really answer this question. I mean, I can give my thoughts, but again, I'm not a landlord attorney, so that I would certainly consult with them around that. But in general, um, your rental agreements, it should say, who will be responsible for uh, the sewer lateral system kind of getting backed up. That's really what that is, right? If it's a problem with the sewer lateral, you probably would be responsible as the landlord, since that is more of it's not cosmetic, it's more of a safety concern now, an issue, right? But if it's just like their kids keep dropping stuff in the toilet, then you might ask them to pay for those repairs, right? But again, I'm not a attorney, right? I would highly recommend consulting with one. That question, Gail, great question though, but that's what I've seen done in the past from my experience, right? If it's a sewer lateral issue that calls the backup, you'd fix it as the landlord. But if it's just like folks dropping stuff in the toilet that live there, then they would typically have to come up with the funds for that, right? Especially if it keeps happening over and over. Yeah, but again, I'm not a attorney. Want to say that, so I can definitely get your question better answered by one of our landlord attorneys. Cool. All right. And so these are some of the resources you'll get sent out to you. It's honestly many more than this, but information about the fair housing and domestic violence laws, the California unlawful detainer information, information about what the inspection should look like with your tenants. Uh, yeah, and we'll give you information about rent control and the just cause eviction law ordinances as well. Okay, cool. So thank you all for sitting through this. I know this was a little heavier today. There were some great questions in the chat. I'm going to actually save the chat, and Gail, I'll be able to follow up more with you. I believe, yeah, Gail, for sure, to confirm some of those answers to your questions. We'll go ahead and do that. But that's all I had. Are there any additional questions for me? And you will get this sent out. I'm going to pause the recording.